Good morning, Dr. Singh.
Good morning, sir. Judge Williams, you're doing well?
I'm well, thank you very much.
Thank you. Let me see if Honorable Chief Justice is here. Yes, I see him. Honorable Deputy Chief Justice, welcome. Honorable Professor Hauha, welcome.
Thank you, Professor. Welcome. Yeah, happy to see you again.
I am delighted. I am very happy to be here with Judge Alex Williams.
Well, you know, the last time we were together, the judges had everybody outnumbered. Now I'm all alone by myself again at Pepperdine. I miss you all.
Okay, Judge. Good, Judge.
You can see this is going to be a very good hour. Professor?
Professor Singh, good morning.
Good evening, my lord. Good to hear your voice, beautiful voice. Thank you for being here and for all your leadership and for your recent trip. We really missed you, and you were fantastic as usual.
Professor Singh, we were colonized by the English. So when you use the word beautiful, it is feminine. When you say my voice is beautiful,
your voice is powerful. How is that better? Powerful.
Thank you.
Thank you.
Thank you so much. Yeah.
Thank you, Professor Singh, Justice Alex Williams. Professor Singh, we now hand to you to invite the Chief Justice so that we begin the session.
Excellent, excellent. Well, Chief Justice, I can't be more happy and feeling blessed at this moment than to have a very dear colleague of Pepperdine, Honorable Judge Alexander Williams, be with me today. He is a man of many, many different talents. But as some of you have seen his video from yesterday, he's also a very wise man and a fantastic mediator who has been a judge in the past. So I thought with your background, my lords, your background in the past, it'll be helpful to hear an ex-judge talk to us about what it is to transition from being a judge to being a mediator. However, Judge Williams, it is a custom, a tradition that we open our classes with a small blessing from the Honorable Chief Justice of Uganda.
Excellent.
Who's with us. And I'm going to invite the Honorable Chief Justice to say a few words before we start, Judge Williams. Thank you.
Thank you, Professor Singh and Justice William. If I'm not mistaken, we were at dinner together when I was over to Malibu recently. Am I being heard?
Yes, sir. Yes.
Oh, you are, yeah. Yes. Professor Singh, thank you so much to you personally and to Pepperdine in general for hosting us, the delegation I led during our recent visit to Pepperdine, and for introducing me to Dr. Marwa. Kindly thank him on my behalf for welcoming and opening his doors to me and my delegation.
Thank you. Thank you.
It was the highlight of our visits to Pepperdine this time round. Briefly, what is expected of a judge to be a good mediator, which is the subject matter before us now, quite interesting, quite relevant, and it comes at the right time when you're speaking to people who are skilled in adjudication work. My understanding from the readings, one, a judge requires a change of mindset, particularly to move from a decision maker to a decision facilitator. There's need to transition from the one to the other. Two, acquisition of skills in building rapport and trust among the parties, as well as between the parties and the mediator. 3, acquisition of skills in enabling and facilitating others to resolve their dispute, to overcome the problem which is keeping them at bay. 4, the capacity to be active and be mindful listener as a mediator. Listen more so that you can understand where the cracks or the core of the problem is, and then you decide how best you can help the parties resolve that dispute. Being an active participant as opposed to a dormant player. Give direction, help the parties move more towards each other. Hard work and elaborate preparation before and during the mediation. The mediator may need to relax the rules of impartiality to fit in the mediator's space, if that will help the mediation move forward, if that will make the parties understand the process much better and come closer towards resolution of the conflicts. Need for flexibility and adaptability, empathy, persistence, not giving up because things are seemingly not moving. Being an investigator of interest rather than issues. The pursuit is understand what are the interests. The characteristics required of a judge are of quite a different order from those required of a mediator. And it is well known and accepted in the profession that eminence and ability in the judicial role do not necessarily translate into the assumption by a former judge of the role of a private mediator. Judges are appointed on the basis of their legal knowledge and experience, and individual judges may have other talents or interests. But what these might be is usually unknown and is not the subject of any formal or informal assessment process. I personally hold the view that a skilled and trained trial judge has the potential to be the most effective mediator for his cases, and then can try those few cases when mediation does not produce a settlement. These and many more define the subject matter which we're honored to have two distinguished professors, experienced and well-skilled in the profession, taking us along. Thank you so much, Professor Singh.
Thank you, Chief Justice. I think, Judge Williams, we can end our webinar here.
Yeah, the Chief Justice has got it all down good.
I don't think we have much left to cover. So that is, Chief Justice, you saved us 55 minutes. Thank you all for joining us today. And
I addressed you in my better capacity of chief student.
You're too kind, and we are honored. This was beautiful words. I'm going to have Judge Williams comment back on your very, very good summary. And after he does it, I have a very small slideshow that I want to share with everybody. Just 4 or 5 photos of the Chief Justice and the delegation visit from a few days ago. And then I will ask my first question to Judge Williams. We have prepared today to sort of make it a Q&A session instead of a lecture. I have 5 questions prepared for Judge Williams. I know he's a dynamic speaker. I know he will teach us a lot. At the same time, I would request all the honorable judges here and delegation to write down any thoughts, any questions comes to your mind, because as soon as we are done with our Q&A, which we hope will not take more than half an hour, Then we have 15-20 minutes of informal discussion organic discussion with this prestigious delegation. If that is okay with you, Honorable Chief Justice, would that plan work for you?
Yes, that's quite fine. Thank you.
Thank you, Judge. Judge Williams, any comments for Chief Justice?
Indeed. First of all, he has used a phrase that I have not heard before, and I thought was brilliant. He referred to our role as that of a mindful listener, combining two of the most important components of what I might want to talk about in terms of what we do. First of all, let me clarify, I am merely a judge, not a justice. I am a retired trial judge from the LA Superior Court, which I mentioned before is the equivalent of the High Court in Uganda and perhaps other jurisdictions. I have some experience before the courts in South Africa. But the phrase mindful listener is beautiful, just splendid, a wonderful characterization of what we have to do. I am delighted that the Chief Justice has identified himself as the chief student. It is the habit, of course, in our judicial world to refer to the chief as the chief. It's a very common phrase in terms of the organization of the California judiciary, and I think of every state, and of course of the United States. Beyond that, I agree with Professor Singh. I am quite impressed with the recitation of considerations and factors, the acknowledgement that there is a different role here from the traditional judicial role, that it requires different skills, it requires different strengths, it requires us to be a mindful listener, an active and not dormant player. I love that phrase also. No one has ever accused me of being dormant. Several people may have wished that I was, but in terms of my judicial career and my mediation career, I am indeed active. There is, in fact, relaxation of the rules to give us the flexibility to exercise various components of human relations, including empathy and persistence, and an ability to identify interests and to see where there might be a potential for a settlement. I think rather than speak further right now, Dr. Singh, I would suggest that why don't we come in with our conversation that you and I have designed.
Absolutely. If you give me just 2 more minutes, this is cross-cultural talk, and one of the planning pieces I've had, Judge Williams, is I had prepared a very brief thank you presentation for the Honorable Chief Justice. If I can share that with the group, that would be my honor, just for 2 minutes, and then we'll go with the question and answer with Judge Williams. Chief Justice, thank you for visiting us. We have prepared just a little small presentation for you. We thought your visit with Dr. Marwa was splendid. He has been given this photo and that he's putting on his wall where he has pictures with Hillary Clinton, Bill Clinton, Muhammad Ali, among other dignitaries. So he thanks you for your visit. I met him yesterday on Diwali festival at his house. Of course.
Wow.
Okay, go backing. Yeah, so thank you. And I will be sharing this PowerPoint with Professor Andrew, so you'll have it. And then with Danny DeWalt, it was a meeting. Thank you for visiting us on this beautiful historic hall for the dinner. You can see Judge Williams sitting on the very right-hand side here. And this is a picture from our dinner that night with the entire delegation. We and the students, and we thank you for your presence that day. We thought that was special because of you. And lastly, Chief Justice, we thank you for also visiting with your delegation our conference on policing and peacemaking the next day. Here is our picture. You are with the ex-chief of police of different departments here in the United States. And I'll be sharing this with you as well. I just wanted to start with that small presentation to thank you for visiting us. We already miss you and we want you back soon.
Yes, please come back soon.
Yes, thank you. I am greatly honored and humbled in equal measure. The honor has greatly humbled me.
Thank you, Chief Justice. I'm going to thank you. I'm going to go with the very first question I prepared for Honorable Judge, and Judge and I have had this discussion from a few years. He has spoken to a cadre of ex-judges, sitting judges, and lawyers in a training we title as MLC, Mediating the Litigated Case. And my first question is very simple, which is just to get the conversation started. Judge Williams, how difficult was your transition from being a judge to being a full-time mediator, please?
Not particularly difficult at all, Dr. Singh. It varies, of course, from judicial experience to judicial experience. First of all, as I think you know, I was on the Los Angeles Superior Court, our trial court, for 24 years. The first 1/3 of those years, 8 years, was in the criminal courts. Then I moved up the street to the civil courts, and that's where I spent the final 2/3 of my career. However, the last 3 years of that 24-year period, from 1984 to 2008, were spent as a full-time settlement judge. That was my full-time assignment by the court. I had no, at that point, I had no trials, no motions. I simply received cases from other judges, typically 3 a day, 1 in the morning, 2 in the afternoon. So I was working as in the full-time settlement arena for 3 years before I left the bench. Now, that's a very unusual situation. And the court now has a half dozen or more judges in full-time settlement assignments based upon the experience they had, I think, with me and one other judge who were the first 2 to do so. Remember, our court has over 500 judges, plus a number, almost 100 commissioners, judges who are appointed by the court or hired by the court. And it is the largest trial court, I believe, any place. But my transition was aided also by the fact that, unlike most judges, including unlike most judges who are in private practice now as dispute resolvers in one capacity or another, I was studying mediation at Pepperdine at the time that I was a full-time settlement judge. And in fact, by the time that I retired from the bench, I was actually an adjunct faculty member, and I've been such for ever since. It's been my privilege to be teaching at Pepperdine for about 20 years. And the institution has not fallen apart during that time. So I'm grateful that it works there. So the transition was easy, but it was somewhat unique.
Judge, what I'm hearing from you is continuous study, a consistency, not giving up, as our Chief Justice earlier said, not giving up, persistence, continuity, study, change of mindset, and ultimately an attitude to learn and grow. Very wise words indeed. Any time to our delegation here, if you have question, please raise your hand or unmute your microphone and ask. My second question is, I hear you that this was not a difficult transition for you because you were at a trial court, one of the most actives in America, and also a presiding judge, also a person who totally believed in resolution of conflict while you were on the bench through judicial settlements. However, there must be one struggle. I want to focus on one struggle, not multiple. What was the biggest and most important struggle that you faced as you transitioned from the bench to the mediation chair?
Actually, believe it or not, the most difficult transition point was actually at the point where I stopped trying cases and on the bench began settlement conferences, not just on my own cases, which I'd done for a few years, but for the entire court, where other judges would send cases to me. And that was dealing with ex parte communication. The whole concept of mediation, of course, includes conferring separately with each side in a case in what is sometimes called caucus, or I prefer to call separate session or private session, because as a judge, you are so hardwired to the fact that you must not communicate separately with one side or the other. That is called an ex parte communication. It is taboo. It violates the most fundamental rules of judicial impartiality. And it was not easy for me initially when I started doing settlement conferences to simply sit down with each side separately. And in fact, I always started the sessions with a joint session usually in my jury room, which was the room I had that had a big enough table for everybody who was participating in the conference. But that was my most difficult transition point. Beyond that, what I did the day after I retired from the court, and if I may please, let me clarify that I'm not technically an ex-judge. I am a retired judge because they can recall me to active duty if I apply and if they wish to do so. I have chosen not to do that. I love what I do. I've always been blessed with having a job that I loved throughout my life, and that is where I stand now. So that was the most technically difficult point. Beyond that, of course, the notion of being paid and separately for the work you do, and the economics of the practice and all were adjustments that needed to be made. But if you work as I do for a competent ADR provider, ADR services is where I work, those matters are taken care of. They will advertise me, schedule me, give me a place to do the work, as I will tomorrow at a big case that I'm handling, and bill for me, collect for me, and pay me. So even those logistics I really didn't have to worry about.
Judge, what I'm hearing from you, if I may, is the difference of process. In judicial settlement or being a judge on the bench, you were careful not caucusing, not meeting people privately. You call it ex parte communication. I would like to hear from the Chief Justice or any of the judges here if that is also taken as seriously in Uganda as it is here in the US. Because what you are then sharing is mediation. One of the tenets of the process of mediation is doing ex parte communication and doing it well through confidence building, through safety procedures, giving people a chance to get comfortable, get confident with the process of mediation.
To feel safe.
To feel safe, to build trust with the mediator, to speak on ideas and topics that he or she may not be able to speak in the joint session. Let me pause
and to be, as the chief said, to be a mindful listener. I want the Chief Justice to know I'm going to be using that phrase.
And a mindful listener.
That's a spectacular phrase. I love that.
Let me ask any of our colleagues, our distinguished colleagues from Uganda, on any comment they have on this particular concept before we go to question 3, which is ex parte communication and the Chief Justice. I see you unmute, please. It is Deputy Chief Justice? Yes, go ahead.
Yeah, for us, communicating with either of the parties before you ex parte is actually prohibited. It would create suspicion to the other party. What are you doing with the litigant? Okay. If you have to talk to the parties, they should be together, or their lawyers should be there. A judge has no opportunity. Well, no judge would be willing to talk to either party separately.
Very similar to here, Judge Williams?
Very similar, and I will tell you that I was present in a courtroom in Cape Town when a lawyer asked a judge that he wanted to meet privately with the judge behind closed doors. And I will never forget the reaction of the judge. He said that in the days of apartheid, many bad things happened behind closed doors, and the doors to his courtroom would always be open. I was inspired by that, and I thought it pointed out the importance of confidence in the judiciary.
I have a hands up by Justice Jeffrey Karabwa. Judge.
Thank you, Professor, and thank you also, Judge Williams. I can resonate with what you have said about that transition in terms of the processes. And I think that is a tough one for someone who has done many years as a sitting judge. Because as Deputy Chief Justice or Deputy Chief Student, as we call him, has said, you know, dealing with a caucus would be really viewed as violating many of the due process rules in trying to resolve a dispute. And yet, really, this is a very good opportunity for you to get to know the parties better, get to know their interests better, without having to have them feel uncomfortable in the presence of the other party. And so I think that's an area to flag, or in terms of preparing one to become a mediator, having been a judge, to look out for. That you also are comfortable in being able to do the caucus so as to extract what is below the line, what are the real interests. So I think that's what I would comment. Thank you.
Thank you, Judge. I really appreciate that observation. I would like to make 2 points that may help clarify some of my transitional concerns, including the one that I've just mentioned. First of all, generally speaking, in the Los Angeles Superior Court, and I think among courts at large around the United States, judges are permitted to conduct settlement conferences. Sometimes it's called mediation. Sometimes the judges call it that. But rarely have I seen, in fact, never have I seen a situation where a judge, against his or her will, was assigned to a court that was a settlement court. It is like you might be assigned to an arraignment court or a first appearance court or a jury selection or a civil trial court or a criminal trial court. Judges normally, it is not expected that everybody who has the privilege and the honor of being made a judge, it's not expected that he or she necessarily would be adept at or interested in, or would feel that she or he was best employed in an assignment that involved a mediation or a settlement conference. I sought out that position from my court. I requested it. They chose to invest in me by that process because I felt that it was something that appealed. It's a phrase I'm sure you may have heard. It appealed to the better angels of my nature, that it allowed me to bring empathy into the process where it would be dangerous and perceived as sympathy and inappropriate if I were trying a case in the traditional mode. So that's the first point I wanted to make. And the second point is, and what you had to say, Judge, underscored it and reminded me for it. One of the variants about judges who are doing settlement work while still on the bench is, shall they be permitted to do so in a case that is before them? And if in fact the case does not settle and proceed to trial, should they continue on and resume the trial mode over the case as opposed to the settlement mode? That is the subject of different rules of different courts. We had a rule in Los Angeles Superior Court at one point that said that a judge should not, but it was should, not a mandatory, should not conduct a settlement conference in a case that he or she might proceed to preside upon, that you should be disqualified. There are other jurisdictions had a flat rule: thou shalt not do that. You cannot do that. And that has varied across the country in terms of settlement work. And in fact, the feeling on the Superior Court was that it was a better process for the litigants to have an independent judge, such as the assignment I have, do the mediation or the settlement conference or conduct it. On the other hand, the argument could be made, the judge who knows the case best might be the best person to participate in settlement. And perhaps you may operate on a process that requires consent of the parties and their counsel to have the sitting judge handle the case. I remember one time trying a case without a jury, and most of the cases I tried were jury trials, and I loved jury work. I loved helping citizens come in and do their duty under the Constitution of our state and our country. It was a privilege and a joy. But in that process, I tried to make sure that everybody consented to my being involved in the settlement. And I will never forget, I was encouraging, I was in a trial, there were parties, it was a family dispute. It was a sad case. I think we've all seen them as judges, where people just couldn't get along and wound up in a messy trial environment and just wanted to get out of it. And I mentioned to them that I had the ability, since I was trying the case, I would not conduct a settlement conference. That was my personal rule. But I had the ability to send them to another judge to consider a settlement conference or a judicial mediation, as you might call it. And I'll never forget one of the litigants saying, "Your Honor, we've talked to a lot of people, and now I'm here before this court to have somebody I respect tell me what the results should be." And that reminded me that we are privileged as judges to be dispute resolvers, not all of us in the alternative modes of mediation or arbitration, but in our primary role as judicial officers of the court. And it was a reminder that my job was to do my job. And at that time, my primary job in that particular case was to try the case. So the issue of, do you mediate or a case that you are still retain some judicial responsibility for? That is one of the variants. The different courts have different responses, even within the courts of California. That's one of the variants, and a very critical one for judges to consider.
Judge, I think we have a comment or question from Judge Wabwire, who serves on, if I'm not mistaken, the High Court in Uganda, but also has studied in the United Kingdom. And let's hear his question or comment. Yes.
My Lord, I hope that's
yes,
the right title.
That's much, Professor, and thank you, Judge Williams. But my question, how has your experience as a judge influenced your approach to mediation, if at all? Has it presented inhibitions, or has it been a source of, strength, or has it eased your work as a mediator?
Very fair question. And I saw that you had a question in the chat, Judge, and I'm glad that you raised it because I would have had to figure out how to open the chat, and I'm not sure I was able to do that. Very fair question. From my point of view, the transition was eased by the fact that I had been a judge, because some of the cardinal rules of mediation are rules that we are innately wired to do as judicial officers. The question of confidentiality, the confidentiality of the proceedings is central to mediation, and it is central to of course, our work as judges is or was in my case. Furthermore, the obligation of impartiality, sometimes described as neutrality, is central to the service, either as a judge or as a mediator. You take the rights of the parties very seriously. So I found that the transition was for me mainly, and it possibly, excuse me, it may be because I had studied not only at Pepperdine, but I had studied at Harvard under the under the days, and when Frank, in
Judge,
fact,
we are prohibited from mentioning the H word in this.
I'm sorry, excuse me, that's withdrawn. Yeah,
Thank
not only does Dr. Singh feel that way because of his affiliation with Pepperdine, as do I, but my primary college affiliation is with a place called Yale, and Yale is biggest rival is Harvard, who we will be playing in football this weekend, by the way. So I forgive me for mentioning the H word, but Frank Sander, of course, was one of the leading lights of the early study of mediation. I had the privilege of studying with him for a while. And because of that, I think the transition was very smooth. But you make a very good point, Judge, and it's one that I alluded to earlier. We do not assume, and the court does not assume, that every judge has the ability, the training, the aptitude, or the interest in being a settlement judge or a mediator, and that preference is respected. I hope that responds.
Thank you, Judge.
Judge, thank you. This is in connection with that thought you're having right now in terms of transitions. My question was more simple in what are the best practices? So maybe this is one of the best practices as you suggested, but what are the other best practices that you have personally developed or seen others develop as they transition from bench to mediator chair?
I think the first rule is do whatever job you have, do it well. Whatever you do, because A, that is the way to get satisfaction out of what you're presently doing, and B, that often is the best way to justify and cause people to consider you for advancement or transfer to what else you might like to do. I have been blessed with a series of jobs in my life, all of which I have loved, and I felt that they were transitions, getting closer and closer to, as I like to say, the angels of my nature. So if you are a sitting judge, be a good judge. Be known in the community as a good judge, one who is fair, who works hard, who of course is above suspicion in terms of corruption or other interests adverse to the judicial obligation. Do your present job well. That's the first step. Secondly is to pay attention, as you all have, to the education in this field. My experience, the experience in Los Angeles, is that a lot of mediators have mediation training, but if they are judges, they often do not. Sometimes they will go through one of our Pepperdine 3-day programs or 5-day programs that we have that Dr. Singh referred to earlier, and that you all have had some exposure to. But generally speaking, the assumption is that if you've been a sitting judge, you may not need that training. And in fact, that some of our best mediators are in fact judges who have never had any type of training other than the training of daily listening to and understanding the interests of the parties and making decisions germane thereto. So I think that's the first rule, is do whatever you're doing, do it well. It's the key to personal satisfaction, and it is the key to advancement.
Thank you. That was very, very helpful, Judge, and maybe a bigger life lesson for many of us. Judge, my next question is on perspective taking. As a mediator, we must take perspectives. We must learn how to take different perspectives. As you left the power of the bench, and we all know the bench comes with power. We all know the story of a judge here in the US who walked into a mediation after he retired from the bench and told everybody, all rise. And this power of the bench, which is so influential, so engulfing, even hypnotic to an extent. How do you work with that power as you shift from that to a mediator? How do you work with that perspective taking, that my new perspective is I'm a humble mediator. I need to here to learn from people, different people, and not have the backing of a big bench and a big title?
Well, traditionally, you still have the title, And in fact, you have the tradition, whatever work you've done, be it, excuse me, you're not a stranger to the bar. You are known to the bar, and your weaknesses and your strengths are known to the bar. And so there is at least the legacy and the title. A retired judge is referred to as a judge, and that's sort of your title for life, unless you do something to cause it to be impeached, I guess. But so you do have that degree of authority. Forgive my voice, I'm sorry. I loved the transition. The greatest weakness that I have is that I have never been a civil practitioner. My entire career as a lawyer had been as a Navy judge advocate and as a federal prosecutor. I had never been a civil trial lawyer, and I had to learn that from the bench. And that matters. In settlement, you do understand the perspective of the parties if you've been in their shoes before. And of course, I am handling civil cases. I've had no ADR experience in criminal cases. There are, of course, various programs involving reconciliation and other approaches to criminal cases, but I'm not familiar with, have had no experience with that. So I think the transition was smooth because of that. The only weakness is I do have to learn from the parties, and I've got some mountainous briefs to read for tomorrow's mediation. People who write briefs should worry about whether or not the reader will get tired of reading before they get tired of writing. At any rate, I will be, as the Chief Justice said, a mindful listener. I tell people God gave me 2 ears and 1 mouth, and I should use them in proportion.
Thank you, Judge. My last question, and then let's open it up for discussion, a Q&A. And if we don't have any questions, we can do a small group breakout exercise. I do know, Judge, that you need to leave soon in about 10-15 minutes for your next appointment. So I will try to stay on time. My last question is, in the US, I have seen a lot of these major panels are dominated by retired judges who are very successful in their post-judge mediation arbitration career. You already mentioned one idea because you carried the title of a judge, the name of a judge, ex-judge, and perhaps that has something to do with it. But
Retired judge, please.
Retired judge. But is there more to that then? However, why are so many judges successful in their transition into ADR?
Well, I think because certainly the judicial skill set, while it is not comprehensive enough to guarantee success as a mediator or an arbitrator, certainly in terms of arbitration, a retired judge who has done court trials without a jury, as we refer to court trials, is someone who is quite used to that process, and it is a direct and ordinary transition into it. I don't know how others, I would characterize their success. It really depends. It depends on reputation. When I first started working at ADR Services, our founder and president, Lucy Barron, a remarkable woman, basically said, "Judge, I'll get you your first case, but you'll have to get yourself the cases that follow." In other words, what you do here will build your reputation. I just heard a big echo. Okay.
Yeah, I was able to mute.
Excellent. That's the best way I can speak to it. Everybody's different, and everybody has frequent flyers, people who use your services a lot, and then it has to do with a sense of success, and it very much has to do with personality. You have to be, as the chief said, empathetic among many things, and when in doubt, shut up and listen.
Yeah. We have about 10 minutes left, dear judges and colleagues. Any questions for Judge Williams or any comments, any thoughts that you would like to share? I don't see your name, ma'am or sir. I see a Zoom user. So please go ahead and unmute yourself. I see a hand. Yes.
Maybe that is Justice Gadenya.
Yes, please.
Yes, I have a question and a comment, but I'll start with a comment. I had a challenge with mediating a criminal appeal, particularly coming from the parties. And I'm bringing this because in mediation, you do the ex parte communication, while in court, it is inter parte communication. I noted that the lawyers were very uncomfortable with the approach that are taken. And what came to my mind is that it's always a good practice, I think, to sensitize or brief the lawyers before one delves into transitioning from a trial judge to a mediating judge. The question that I want to ask, I actually put it in the chat, is that as a judge, mainly we are interested in fault finding to determine who is right and wrong. And yet in mediation, the focus is on helping the parties, in most cases, to find a mutual settlement to their problem. My question to the judge is, how difficult is it to move from a fault finder to a mutual solution finder?
That's a wonderfully phrased question, and I really appreciate your following up on it. It can be difficult. You know, we are used to making, and particularly if you've been in a high volume court like I was, where I had 1,000 cases and trying to take care of, I would set probably a half dozen for trial every Monday, and hopefully find ways to deal with them by the time they got to that date, 6 months or 8 months downstream. It is difficult, and there are times when I read a brief and I say, seriously, are you crazy? But then I have to suspend that, and I have to shut up and listen. And it's surprising how many times, if I shut up and listen, I understand better where they're coming from, and perhaps my reaction about who is, quote, right or wrong may be misplaced. I remember the first time I tried a jury trial in Superior Court as a judge. I was so surprised at the verdict form that I almost asked the foreperson, "Madam, did you sign the right form?" I didn't go that far. That would have been not a good thing for a judge to do, to undermine the decision of the jury. But I was surprised about it. So I learned that the viewpoint of Alexander Williams is not necessarily the universal justice viewpoint of every question that comes up, and that the parties are entitled to pursue their interests, even if there is fault in the analysis. And if there is, after I've listened to them, if I find that I might disagree with them, I won't say you're wrong. I will say something, usually a question. The best defense mechanism, I believe, for a working mediator is the ability to ask questions. So instead of saying that's just flat wrong, I'll say, have you considered the possibility that a court might say the following? Or have you considered the possibility of what are your thoughts about how the other side will answer that perception? And if you ask questions, you are guiding the conversation without necessarily expressing a direct opinion. And I think that's the best way I keep my fact finder self from extinguishing my my solution finder skills.
Can I add to that? Yeah, that's a great comment. No, definitely. I think this idea of having patience with the process.
Yes.
Is let the process pay out. Last night, I had Richard Burke, our good friend from Oregon, visit us. and we were discussing to our advanced mediation online class for US students. And one of the things Richard mentioned was that in advanced negotiations, which are part of every advanced mediation, there is a tradition of going back and forth, a custom of high offer, low offer, bargaining. And you cannot just break that custom. You cannot just say, okay, one offer only and we are done. And having that prudence and patience that will come out after parties had struggled with each other, even though you, as being a judge, as being an expert in the field, can predict the outcome, having the patience not to share that prediction till the very end as needed.
I also, if I may add one additional comment quickly, I very much enjoyed two aspects of my trial work more than any other when I was on the bench. They were jury trials and settlement conferences. And if you can see the common element in both of those, the essence of my judicial function was to help others make decisions, be they 12 jurors or parties in a settlement. And I think that is, and to this day, I enjoy that aspect of the case. I enjoy actually not having the burden of making an actual decision about who's right or who's wrong. I have the duty to be attentive to the risks that they have, that they may be found to be right or wrong if they do not settle. But I don't have the burden of making that decision. And I find that, for me personally, liberating, because it allows me to explore, to be curious, and to help them find their way.
That is an excellent point. Curious, liberating. Mr. Mao, you have a question? Please unmute yourself. And Judge,
thank you very much.
Please, yes.
Thank you very much, Professor Singh and Judge Williams. Sorry, I came to class late. I was traveling from about 350 kilometers away. Now, judges also do mediation. And then you have the mediator, those who are not judges. I'd like Judge Williams' thoughts on the difference between mediating as a sitting judge and then mediating as a mediator. Thank you.
Well, I will tell you that in California, there's no such thing technically as a mediating judge. The term is settlement conference, and it's usually called a mandatory settlement conference because, and that's the big first difference, is that you, as a judge, you have the ability to order a settlement conference either before you or before a colleague, if she or he is willing to take the case. And that was my job, as you know, for 3 years, to take cases from other judges, as I did every day. You have the authority of the judicial office, and that colors everything, even if no matter how impartial you are and how neutral you are in the process. I think that the obligations of the judiciary aided me in being an effective dispute resolver on the bench. Of course, in retirement, you don't have the authority. You have arguably the prestige of having been a judge, and hopefully the expertise that comes with that. But you don't have that authority, and that authority does matter.
I had taken the liberty to post the California rules in the chat, Judge Williams.
Excellent.
And
3.1380, know it well.
Yes, sir. Okay. As we have last 3-4 minutes left, and maybe I'll join. I would request the Chief Justice to give closing remarks for today's session. My apologies on behalf of Pepperdine that we did not realize the timing has switched here because of daylight savings. We started 1 hour late, and I know some of you were waiting an hour earlier.
Oh, I'm so sorry.
Yes, so our apologies. We had assumed the world knows about America. We are quite self-centric, ethnocentric here. And Professor Andrew was very kind to email me, call me, and my apologies, brother. And for anybody who had to wait, certainly my apologies to Chief Justice. Chief Justice, would you like to end our session for today, please?
Thank you, Professor Singh. I must decline because it is a well-guarded rule of practice amounting to law that the chief student kicks the ball and then the deputy chief student loses the match. So I hand over the ball to the deputy chief student to make the necessary remarks. Thank you.
Judge, you create the rules here, so I only can say thank you. Yes.
Thank you very much, Chief Justice. I wish to say it on behalf of the students that the discussion by Professor Singh and retired Judge Williams was very useful. It's a teaching skill that is practical, and we are learning from practitioners of long experience and great wisdom. So this was a useful evening, time well spent, and we are happy about it. So thank you very much. Good night.
Thank you, Chief.
From my side, Judge Williams, as always, thank you from the bottom of my heart and my mind for your time and for your excellent teaching.
Thank
Everybody,
you for the privilege of participation. It was an honor.
Thank you, Judge. We will be closing the webinar right now. Have a good night, everybody. Thank you.
Thank you. Bye-bye.